Welcome to Ground Rules, Employment Law Over Your Coffee Break. My name's Pam Howland, and I'm here today with Doug Plass and Jennifer Walrath, and we're talking about LGBTQ protections under the law. That's an area that to us is changing and in flux somewhat in 2025, and it creates questions and uncertainty for employers. So there have been some new developments in that recently, which is why we want to take this opportunity to talk about that a little bit further. So, as a backdrop for this, from our perspective, the starting point in trying to understand what the LGBTQ plus protections are or are not, the starting point is to look at a 2020 United States Supreme Court case, the Bostock case, which basically says Title VII's prohibition against discrimination based on sex includes discrimination based on gender identity and sexual orientation. That's still good law. Somewhat that creates the backdrop that we want to think about these issues. So we've got the 2020 Bostock decision. In 2025, what we know is that early in 2025, we saw some executive orders from the new presidential administration that created some uncertainty and confusion. So on January 20th, 2025, one of those executive orders was entitled Defending Women from Gender Ideology Extremism and Restoring Biological Truth to the Federal Government. Purpose of that executive order, as defined by it, was to define sex as an immutable binary biological classification and remove recognition of the concept of gender identity, including in sex protections and in agency operations. I know that's a mouthful, but I had to read that because I wasn't sure I could paraphrase that accurately. So we have this January executive order, and there have been others since then too, but that is one that definitely goes to this issue. And again, has created uncertainty for employers as to what does that mean and how does that impact the law. We know that in May of 2025, there was a federal court decision that nullified portions of the EEOC's guidance on workplace harassment. That guidance came out last summer, and it specifically addressed harassment in the context of gender identity and sexual orientation. A federal court basically nullified those portions of the EEOC guidance. So we also have EEOC directives, communications indicating that they are not pursuing claims of discrimination based on gender identity and sexual orientation. And now on July 29th, 2025, there is a federal court case in the District of Maryland against the EEOC related to the EEOC's position that it has taken over the past few months and its reluctance to prosecute claims of harassment or discrimination related to LGBTQ plus discrimination. So let's talk a little bit about that most recent lawsuit, the one against the EEOC, and to talk about what that really is and how it could impact things. So I'm going to turn it over to Doug and Jennifer and get their perspective on that to really hear more about like what the heck is that lawsuit that we're hearing about and what are some of the like key allegations in it.
So this lawsuit's brought by a legal services nonprofit in Maryland called Free State Justice that serves LGBTQ plus individuals. This lawsuit alleges that the EEOC has implemented a number of things that it calls the trans exclusion policy. So there's kind of 5 things I identified from this that the EEOC has done. So one thing is the EEOC has halted charge investigation processes for charges tied to sexual orientation or gender identity. This lawsuit further alleges that it has moved to dismiss its own employment discrimination lawsuits brought on behalf of transgender people. It has directed all charges of gender identity discrimination to be classified as meritless and suitable for dismissal. And now accepts only standalone hiring, firing, and promotion claims related to gender identity, but no others, including those that have other components with them, such as, for instance, a retaliation component. And then the last thing is that the EEOC has stopped paying these fair employment practices agencies. These are the state agencies that partner with the EEOC for investigating charges based on gender identity. So that's kind of the background. And there's 6 claims in this lawsuit. The first one is that the EEOC has acted beyond the powers granted to it by Title VII of the Civil Rights Act. Another claim is that equal protection under the law was denied by the EEOC by denying service to these transgender individuals. And then there are 4 claims related to violations of the Administrative Procedure Act. 2 of those are kind of mirror the first 2 claims, that the EEOC acted contrary to the law in excess of its authority, and also contrary to constitutional rights. But there are 2 other claims that are violations of the APA as well, including one that says the EEOC's actions are arbitrary and capricious because it relied barely on political preferences and an executive order to make these decisions. And also that it acted without the observance of processes when it made these changes without having a quorum, and kind of discarded its own guidance documents in the process. So what this lawsuit seeks is a declaratory judgment saying that what this trans exclusion policy is not legal, and an injunction prohibiting all these things from being implemented.
Yeah, that's interesting. So if you're listening to this and you're like, what the heck is the APA? I mean, these are the type of claims that an Administrative Procedures Act, right? Okay. Again, we don't really do like challenges against federal agencies. So it's a little bit beyond what we do too. But these are the type of claims that are not uncommon against a federal agency, challenging the way they made its decisions and challenging its authority and the way that it's applying the law to the decisions it's making. So you don't really need to get bogged down in the details on that, but basically saying, look, EEOC, you overreached here.
And I guess what I keep thinking about, and what we were kind of talking a bit about before we came on air, is, if you're an employer reading articles about this, even keeping tabs on the EEOC and its press releases and trying to kind of follow what's going on, I think it's difficult. Because a lot of the news out there would suggest that, kind of these protections are either gone or going away. And I think I would caution that's not necessarily the case, at least from a legal compliance perspective. But there is a lot happening, and it is difficult to kind of keep track of it and within your own workplace, when you're trying to follow the law and do the right thing and, have an environment where all of your employees can feel safe and have a productive workplace. I think it's a very large challenge. I would say, obviously, we're going to keep tabs on this lawsuit because whatever happens with this uh, it could add to the confusion, but it also could settle some things, but I think it will take some time. But all to say, yet one more reason why this is definitely an area where uh, the law is unsettled, as Pam said at the outset. And I guess it's a very, very long way of coming back around to, if you're an employer, this is not a settled area of the law. There's a lot out there that's changing. I think these are probably the kinds of issues where you just don't want to make decisions based on assumptions or things you read in the newspaper. And you're going to have to really dig in, maybe even get assistance from like your HR people, an HR consultant, legal counsel, to kind of figure out what is the lay of the land for us and what do we need to do or want to do with our operations to, kind of be compliant and have the kind of workplace that we want to have.
Yeah, I would say that is the number one takeaway. This area is completely in flux and somewhat up in the air right now, but we still have that United States Supreme Court case. That has not gone anywhere. So it would be very dangerous, I would say, for an employer to assume that there are no LGBTQ protections in place because there is still the States Supreme Court case. So, I mean, we didn't really talk about the fact that this lawsuit is against the EEOC. And again, that's the federal agency overcharged with making sure Title VII and these other anti discrimination statutes are complied with. So we have the EEOC, this federal agency, and where we're at here in Idaho, an employee could bring a claim against against its employer to either the EEOC, the federal agency, or the Idaho Human Rights Commission, which is the state agency. We see most claims going through the Idaho Human Rights Commission. We know they have a work share agreement with the EEOC. Once in a while, we get something from the EEOC if maybe there's a conflict and it gets channeled to the EEOC instead of to the Idaho Human Rights Commission. But there's also, somewhat of a question as to whether state agencies charged with enforcing state anti discrimination laws, in our case, the Idaho Human Rights Act, are going to take the same approach as federal agencies. We had, if you recall, if you've been listening to us since we first started early in 2025, we did have Ben Ehrwicker, the director of the Idaho Human Rights Commission, on with us. And we did talk about this issue a little bit several months ago. I mean, geez, it's probably been, maybe that was in February, but it feels like it feels like a very long time ago, but remember, he said at that time that the Idaho Human Rights Commission is still taking charges related to this. So, I don't know if that's changed or not, but I think that is also something employers should be very careful about because there are a lot of layers of complexity to this issue. And again, we just always go back to there is a United States Supreme Court case that says it's illegal. Everything else is kind of, balls juggling in the air. We don't know what's going to happen. But employers should definitely stay tuned and keep their eyes open so they're making sure they can comply with this law.
Couple other thoughts to tag on to what Pam was saying. One is, um, I think actually Doug and I were chatting about this before we came on air today. It is potentially possible that if someone were to file a charge with the EEOC and the charge doesn't get prosecuted any further by the EEOC, perhaps that person could still go to court and file a claim in court and say, I did my best to go through the process and now I'm going to go to court. It's a little unclear what would happen in that situation, and it might vary by jurisdiction, but certainly that's not impossible, right? So you may well still see claims in courts by employees, still trying to pursue their claims despite sort of recent developments with the EEOC and its decision to not pursue those kinds of charges. The other thing that, kind of looking in kind of before Bostock, that I think is also important context here uh, for I think decades, it's been the law in the Supreme Court of the United States, right? So the highest court in the land, that treating someone, differently or harassing them because they do not conform to gender stereotypes can violate Title VII. So, even before Bostock, that was sort of the law. And, I do think that is a cautionary point for employers that a lot of the current discussion and dispute tends to focus on Bostock, quite rightly, but I do think it is informative and very interesting that that is not the only case that kind of relates to this subject, and it really wasn't as novel as one might think that Bostock made the decision that it did. There was already kind of precedent out there that supports this notion that you shouldn't be treating people, your employees differently, or coworkers shouldn't be treating their coworkers differently or harassing them because they don't match up with someone's conception of what a particular gender is like.
And I think it's worth talking a little bit about the facts of that case because it is like an interesting part of case law development analyzing Title VII protections. Do you remember, Jen, for yeah.
Oh, actually, yeah. So the case I was referring to is in the U.S. Supreme Court. It was called Price Waterhouse v. Hopkins. Um, it was from 1989. So, quite a long time ago at this point. It was a claim brought by a female employee. She alleged she had been denied a promotion because she didn't conform to traditional female gender norms, that she was macho. Coworkers and people who were making this promotion decision commented that she needed to walk more femininely, talk more femininely, dress more femininely, and wear jewelry. And the U.S. Supreme Court held that she had an actionable claim under Title VII. Sort of relatedly, and I didn't mention this one earlier, but there is also a Ninth Circuit case, right? So here in Idaho, for federal courts, we are within the Ninth Circuit, from 2001, uh, where a male employee claimed that he was verbally abused because his coworkers and his supervisors perceived him to be effeminate. And the Ninth Circuit found that conduct violated Title VII. So those are the kinds of cases. I'm sure there's many more out there, but those are very notable ones that are examples of the kinds of conduct that, I would say is still good law and is the kind of behavior that could lead to a claim under Title VII or potentially even under Idaho state law.
Yeah, and I think there is also, I'm trying to remember the case, but there's also the Supreme Court case about the oil rig workers, that Oncale, that said really similar to the thing to that Ninth Circuit case as well. So yeah, and that's I think from the 70s or something. So this has been going on for a long time. I might be wrong about the date on that one. So yeah, I mean, I think we tend to think about these issues as new and emergent, but they really have been something courts have been wrestling with for a very long time, really since the beginning of Title VII. And there's good law. So, despite what the EEOC is doing.
Yeah. Yeah, and to touch a little bit on what Jennifer was talking about with administrative exhaustion, I think that's a really interesting concept. What if you're an employer and you've never had a Human Rights Commission complaint lodged against you, that might be a foreign concept to you, but under many state human rights acts and under Title VII too, yeah, if you're an employee and you bring a claim, you have to first exhaust your administrative remedy, which means taking it to either the EEOC or the Idaho Human Rights Commission, letting them investigate it, consider it, and make a decision on it before you can take your case to the courthouse. It's what we call administrative exhaustion. And here in Idaho, sometimes that means that you might bring a complaint and it might be somewhat on hold for a year or so while the Idaho Human Rights Commission analyzes it, investigates it, and reaches a conclusion as to whether there's a probable cause of discrimination or not. What Jennifer's saying is, if the agencies make a decision that we're not going to hear your claim, it might be possible that then an employee seeking to sue their employer can go straight to federal court and say, I did exhaust my administrative remedies. I went to the agency, they refused to investigate it. So there is no exhaustion route for me. So now I'm going straight to the courthouse. So we don't know if that'll happen or not. It hasn't happened yet. These things are cutting edge happening, right as we speak. But that is, one more, cautionary tale to employers is there's a lot of scenarios here that could still result in lawsuits. And, again, the law still is the law. These things are certainly confusing and creating questions and are uncertain, but we still have some law in place that you definitely need to be following still.
Yeah, so I think maybe some of the employers out there are kind of wondering, what do we do with this? And I think I said earlier, one thing I would say is think about it, right? Dig into it, see what this means for you and talk about it. I've also become a big proponent of like a respectful workplace training and really focusing on your respectful workplace policies. If you have two employees who have very differing views on these issues, can they still work together civilly in the workplace? I don't know. I would like to think so, but humans are as humans are. But I think as an employer, you certainly can expect that of your employees to be civil to one another. And that might well be one of your best tools, right? To try to manage your workplace, kind of um, discourage incivility and discourage the kind of behavior that otherwise might lead to someone saying, I'm being harassed, I'm being bullied, I'm being treated unfairly. Um, you know, I've been denied something because of who I am or what my beliefs are, things like that. Like, I think that really could be a very good tool and something that hopefully a lot of employers already do. But if that isn't something that's kind of in your quiver, I would definitely add it. Um, and that could be useful in trying to um, manage your workplace while sort of some of the developments are happening right now and it's a little bit in flux. Because that part isn't in flux, right? Sort of expecting respectful workplace behavior and civility, safe, right? Good thing to expect, good thing to do, something you can do, you should do, not something that's changing.
Yeah, and have good policies in place, written, and importantly, enforce them evenly, right? So, you know, don't enforce them for these issues and fail to enforce them in other areas where people are treating each other uncivilly. So, kind of even-handed enforcement and pay attention to what's going on in your workplace will go a long way to avoiding these things.
And if you're listening, chances are you might be an HR professional, an attorney, in-house counsel, a leader, an owner. If you're listening and you think, this is kind of confusing, I agree. I'm not sure, going into this podcast, I really wasn't sure what the state of the law is. If you're thinking that, then you should really be thinking, what are our supervisors thinking? Because we know your supervisors are the ones who are going to see the type of stuff that Jennifer's talking about, the respect, the incivility, potential problems. They're going to need to be the ones that are bringing issues to the higher leaders, higher level leadership, so they can be appropriately dealt with. So are your supervisors aware of this? Do they understand the law? Do they understand your policy? Do they understand how not following the policy can really impact your culture? If not, should probably get some training and communication going there. And I understand it's not a black line. Here's the law right now. It's kind of gray, but even that being the case, they still need to know and understand the issues. So we will keep you informed on what happens here. It's an interesting issue and definitely one I think we'll probably see something about before 2025 ends. So we'll keep you updated on that. In the meantime, we've got our Law for Leaders book. Jennifer wrote on this. She's tracking Title VII in Chapter 6 that talks about workplace discrimination and harassment. So check that out. We've got our Law for Leaders training. We've got recorded content. We've got live content. We love to come and speak to workplaces, leaders at all levels. If this is something you need assistance with, we'd be happy to come and talk about that. Otherwise, that's it for today on Ground Rules, and we'll see you next time. Ground Rules hosts and guests are not providing legal advice in this podcast. Do not act upon any of the information discussed in this podcast without first consulting a licensed attorney in your jurisdiction.